The Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning. Welcome to the July session of the Court of Criminal Appeals here in Knoxville. I am Judge John Campbell from Shelby County. I'll be the presiding judge today. To my right, to your left, is Judge Tom Greenholtz, who is from Hamilton County. And on my left, to your right, is Judge Kyle Hickson, who is from Knox County, and will be your panel today. As most of y'all know, we have the usual admonitions, I guess, this morning is 20 minutes aside. The appellant, if requests some additional time for, or reserve some time for rebuttal, please let us know on the front end and we will make that noted. Also, we have read your briefs. We don't necessarily have the opportunity to read all the records, so be mindful of that. Do we have any preliminary matters?
Yes, Your Honor. The Attorney General has an attorney that she would like to introduce to the court this morning.
Please come forward.
Good morning, Your Honors, and thank you for the privilege of allowing me to introduce Ms. Abigail Renard to the court today. This is Ms. Renard's first argument in the Leslie Hearn case before this court. She's been with our office for about a year now, working on brief cases, but Ms. Renard is from Pennsylvania and has been steadily moving her way south throughout her career.
Good for her.
Yes. Yeah. She tells me she's very excited to be moving south.
Good.
But she's attended Mercyhurst University in Pennsylvania and then the Columbus School of Law in Washington, D.C. Before joining our office, she spent about a year doing criminal appeals in New York. And I know she's an avid hiker and very excited to be here in Tennessee with our many state parks. But I was very pleased to introduce Abigail Renard.
It's very good to have you. We're looking forward to hearing from you and participating in these oral arguments, and hope you enjoy it as much as we do.
Thank you. Great to be here.
Thank you.
Thank you, General. Thank you.
Madam Clerk, could you call our first case for us, please?
State of Tennessee versus Kelli M. Davis.
Good morning. May it please the court, T. Scott Jones for the appellant, Kelli Cates, out of the Knox County Criminal Court Division, particularly Judge Stephen Sword. I would like to reserve 5 minutes of my time for rebuttal, if possible.
Yes, sir.
As you indicated earlier in your preface before we began this session of the Court of Appeals, obviously, I'm aware that you've read the briefs, that you're familiar with the facts and circumstances surrounding the same. This case does present somewhat of a unique posture, albeit not one that the court doesn't see on a regular basis. That is a plea in a DUI case with reserved issues. There were great pains taken, and sometimes I wonder whether or not those pains are taken appropriately or not, i.e. the complaint is if we don't put enough, that we didn't put enough to sufficiently narrow the issues, and if we put too much, our verbosity is questioned with regards to that. But that being said, the issues reserved are those that we present.
It can be a trap sometimes, Mr. Jones.
Excuse me?
Said it can be a trap sometimes.
Yes, absolutely. And so we're kind of sort of in that catch-22, if you will, with regards to it. We've endeavored to do that to the best of our ability. We have narrowed, obviously, our issues at the trial court level. It was done with the certification of the trial judge as well as the consent of the Attorney General. The facts and circumstances are what they are. I mean, they are without question that it occurred on October 6, 6, 2019, about midnight, we receive a unsubstantiated report, just a call-in. They get a BOLO, so to speak, for a black Jeep, not a black Jeep Patriot, not a black Jeep Patriot with a Tennessee license tag, not a black Jeep Patriot with a Tennessee sticker on the back of it or a flag on it, anything of that nature, somewhat of a ubiquitous type vehicle as far as traveling the highways and byways. The actual traffic stop occurs on Cunningham Road.
Mr. Jones, I'm sorry, because our time is limited, I wonder if I could ask you some jurisdictional questions before we get into
Yes, Your Honor.
some of that. Do you agree that the Preston requirements are jurisdictional?
I apologize, Your Honor.
So do you agree that the Preston requirements are jurisdictional?
Yes, Your Honor.
Do you agree that we have to, irrespective of what we may wish to do otherwise, do you agree that we have to construe them strictly?
Yes, Your Honor.
Do you agree that the certified questions must contain your arguments that were made before the trial court?
I agree they do. And
Do you also,
to the extent
do
that
you also agree that the certified questions have to include the rationale that the trial court used in denying the motion?
Your Honor, I mean, we rely to a certain extent on certifying those, and then
Sure,
what actually gets put in there by the clerk's office with regards to the actual
In this case,
certification.
in this case, of course, the certified questions were the subject of an email to counsel. The certified questions were presented in the plea agreement, and the certified questions were also then put into the judgment. But do you agree, though, that just as a matter of law, that the certified questions must contain the reasons that the trial court gave for denying the motion to suppress?
I think they do, but I think incorporated in the court's record is actually the findings of facts and conclusions of law regarding the motion to suppress.
I agree.
And I think that becomes part and parcel.
Do you agree that Preston, though, requires that the reasons be given in the certified question without reference to the record?
To the extent, I think it would be disingenuous for me to argue with the obvious with regards to that, but that being said, I think as far as the outline, it's fairly obvious what the issue is with regards to that, in that the court found reasonable suspicion based upon the articulation with regards to the BOLO, and then the subsequent discussion with regards to effectively the roadway lane traffic violation, whether it be under roadways lane for traffic or whether or not it be under driving on the right side of the roadway.
I'm glad you mentioned that, because it looked to me like the trial court actually had, in its legal conclusion, was that there was reasonable suspicion to believe that your client was operating a vehicle under the influence of an intoxicant. And it looks, when I review the transcript, that the trial court relied upon the presence of the BOLO. We can talk about whether that's appropriate or not, but that was one of the bases for the finding of reasonable suspicion, weaving inside of the lane. And at that point, the trial court found that there was at least reasonable suspicion to conduct an investigatory stop. So if I were to look then at the very first issue, that the certified issue that is here, it says the issue is whether evidence from an automobile stop can be used against a person when the stop was made by a law enforcement officer who did not observe nor believe the driver had crossed the roadway boundary as required by the Tennessee Supreme Court's interpretation of Tennessee Code Annotated 55-8-115A in its ruling in State v. Davis 2015. So that statement of the issue does not identify the action that the trial court took, whether the trial court erred in denying a motion to suppress. It didn't identify the reasons for it. It doesn't identify the reasons that you advanced in your motion. So in your original motion, you talked about the BOLO. At the original hearing, the BOLO was mentioned by you all. Your motion actually cited 55-8-115A, which is the State v. Smith statute.
Yes, Your Honor.
But yet in this certified question, I mean, you cite here only the one statute. You don't cite the Smith statute, which is 55-8-123-1, or Benet. In the brief that you have to this court, you also discuss the impact of the BOLO, and you discuss the reasonable suspicion of DUI, but none of that appears in the certified question. The Preston requirements are technical. As a matter of policy, I don't really think it much matters whether I agree with them. As a matter of policy, they are what they are. Given that those requirements are pretty clear, would you agree that the first issue itself doesn't satisfy the Preston requirements at all?
As far as when you're talking about the first certified question with regards to that, I guess respectfully I would disagree because it's quite obvious what the court did with regards to
Let's
it.
just take the language of the
Right.
question. And I appreciate you being patient with me.
Certainly,
we
Your
have we have good history together, and I appreciate you being present with me. Just take the language of the first question. Can you identify what action the trial court took simply upon the basis of the language of the question?
Quite obviously, they, at least to me, albeit perhaps not to
I
you,
have
and
to-
obviously you're raising
I
an
have to-
issue with regards to it, the fact that they took issue with the, if you will, crossing the center line of the roadway, or excuse me, crossing roadways on roadways lane for traffic and/or driving on the right side of the roadway. as far
I
as
actually
encompassing.
I have to refer to the record,
Yes,
I
sir.
believe, to see what the motion to suppress alleged. I think I have to refer to the record to figure, to determine what the trial court actually held. Did it affirm, did it deny? I have to refer to the record to determine the basis for the trial court's holding. Is the position here that the first question complies with Preston?
Yeah, I think on its face, at least from our argument standpoint, I mean, the part and parcel of why Ms. Cates entered the plea was based upon those certified questions that were done in concert, not only with the Attorney General's office, represented at the point in time by Robert DeBusk, but also with the concordance of the trial judge. So, I mean, obviously, they knew that it was going to come up with regards to that, and that being said,
I realize the unfairness.
I mean,
In some cases where I've got a district attorney in the trial court that says, I think these are dispositive. We can come to that here in just a second.
Yes, Your Honor.
I think these are dispositive. The trial court says, yeah, I think they're dispositive also. I hope these meet the Preston requirements, but the burden is always on the defendant.
Certainly.
And the problem is, and this is why I asked the question to start off with about whether they're jurisdictional. So the actions of the DA and the trial court below cannot confer jurisdiction here if jurisdiction doesn't otherwise exist. And I recognize the inherent unfairness of that because you're relying, I think, in part upon the trial court. At the end of the day, I wonder, though, if that is
well, I
relevant to
think then
Preston.
it basically presents the same situation. You know, that being said, obviously then it is a knowing the question would be then would it have been a knowing voluntary plea without
post-conviction
incorporating that. So, you know, I get that the court's not in a
post-conviction
position
question.
of postulating on things that quote unquote are not before the court, but I think when you read, if you will, effectively the 5, if you will, certifications associated with that, again, and just like what we pointed out at the beginning with regards to it, you know, it puts defense counsel in a particular box with regards to, I mean, how brief you want to go or how expansive that you want to go. And here, you know, obviously we refer to code sections and we also refer to case law with regards to the basis of what the court's decision was
But you
with
don't
regards
refer,
to that.
but you don't refer to the BOLO. And you don't refer to actually the issue the court was deciding, which was whether there's reasonable suspicion to believe that the driver was impaired. And so maybe kind of along those lines, just dealing with the first question, it doesn't seem to me that the first question would be dispositive of anything. Because even if the defendant did not cross the center line, and so therefore didn't violate the statute as the Supreme Court interpreted in Davis, that doesn't mean that reasonable suspicion doesn't exist otherwise, simply by swerving in the lane, moving in the lane. We've got to deal with Benet, we've got to deal with the other statute in Smith as well. But what I'm saying is that simply because you didn't cross over the center line doesn't mean that reasonable suspicion doesn't exist, because in fact there were other reasons relied upon in the trial court, including the BOLO.
I think when you look at the beginning of that, and when I was going to the BOLO, I was merely going as far as to a factual history of basically how Officer Smith, and I believe that was the gentleman's name that effectuated the stop for the Knox County Sheriff's Office, basically approached. And Officer Smith was forthright in his testimony. He indicated that basically he did not observe, and he was asked the specific question, I recall this, as to whether or not he observed any violation of Tennessee law, and he answered.
I actually may agree with you on the BOLO. We'll see. We'll ask the Attorney General about the
Sure.
view on the BOLO, but I think there are issues in the BOLO.
Right.
Problem is that a BOLO is mentioned not a single time in any of your 5 questions, and the trial court relied upon that.
Right. Well, I
have-
understand that,
do we
but
have jurisdiction?
I look at it as looking at its lineage from how did Officer Smith get there? Whether or not the BOLO's good, bad, or indifferent with regards to what did Officer Smith personally observe? That being said, Officer Smith as an individual, and we know the requirements with regards to, when we're talking about misdemeanors or things of that nature, investigative stops, what did he see, hear, or observe? And that being said, in this particular case, he actually testified in the affirmative that he did not see any violations of Tennessee law. And so I think when you look at it under that set of circumstances, it creates that issue. And then obviously that's why we effectively had 5 certified questions associated with it.
Okay, thank you. I appreciate your patience with me this morning.
Right. And I don't know where I'm at. Obviously, you know, I mean, I know where I'm at. I don't mean it from that perspective. I'm not sure if my 3 minutes and 18 seconds is part of my 15 minutes or if I've already gone over. But that being said, I don't want to have something and have nothing left in return.
You should start getting a light.
Okay, right. I just didn't know if that was running down my 15 minutes or if it ate my 20. So, you know, I think obviously I appreciate that, Judge, as far as our in-depth discussion with regards to that. I think when you read the others, you read the record as a whole, particularly, and then you look at the decisions that we've cited, including Puckett and the others, and you look at the distinction between that and Aaron with regards that simply, you know, a vehicle touching the line is not enough. And so I think under that set of circumstances, in this particular case on October 6, 2019, Bolo or not, you have Officer Smith. The fact pattern is irrefuted. He makes a turn, a U-turn, follows. The report is on Topside Road, not Cunningham Road. This black Jeep, albeit perhaps in the same approximate geographical area, it's not in the exact area where the reported black Jeep is. As I was stating at the beginning when you had questioned me, I mean, black Jeeps are somewhat ubiquitous. I mean, it's not a situation where, you know, it was a pink Mary Kay Jeep and everybody go, oh, that's that pink Jeep. But that being said, when you observe that and you observe what the law enforcement officer articulates as far as what his basis for stop and says doesn't have effectively any violation of Tennessee law. Obviously, Ms. Cates relied upon us with regards to this, and we likewise cooperated with the Attorney General's in framing the questions to be posited to the court, and she entered a plea based upon that decision. So I understand what the court's pointing out with regards to that, and that obviously is something that will be a question of concern and something of examination, obviously, where we will laboriously outline those. But I think with the certification, and obviously I understand that, you know, this court operates independently of that of the trial court, but the trial court in and of itself thought they were dispositive, as did the Attorney General's office. So under this set of circumstances, I think that they did not have, if you will, articulable, reasonable suspicion, probable cause to stop Ms. Cates, and thus everything that flowed thus far. I think had the officer said, hey, you know what, I pulled her over, I was going to give her a ticket for this, or she did that, but when he actually articulates, I don't see any violation of Tennessee law, I think that becomes a particular problem for the state.
State.
Good morning, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should dismiss the appeal because the defendant did not strictly comply with the requirements of Rule 37, or in the alternative, affirm the judgments because the trial court properly denied the motion to suppress where officers had reasonable suspicion of driving under the influence. I'll turn to the first issue, which Judge Greenholz, you honed in on. The defendant here did not strictly comply with the requirements of Rule 37. And I understand this court's frustration. Sometimes I believe it's previously called Rule 37 a quagmire of jurisprudence. But nevertheless, the requirements of Preston and of Rule 37 must be strictly complied with. And here the defendant didn't do so in 3 different ways. And I think Judge Greenholz, you pointed on all of them. None of the certified questions specifically identify the reasons or the bases relied upon by the defendant in his motion to dismiss, or motion to suppress. None of these certified questions identify the trial court's reasoning for denying the motion to suppress. And I think if they had, it would show the third reason why, which is that none of these certified questions are dispositive on appeal. All 5 of the certified questions focus on this issue of failure to maintain lane or staying in this roadway boundary, and whether if you touch the line versus crossing the line, whether that constitutes a traffic offense. But that was not the issue before the trial court. And that is not the trial court's ruling. I think you mentioned it.
The trial court didn't actually make a ruling that there had been a traffic violation, did it?
No, and I think the reason that there might be some slight confusion is because the trial court does reference that this jerking in the lane and touching these lines contributed to the totality of the circumstances, and the court does cite Smith, but not as a basis for its ruling. And again,
Was it important to the trial court that the BOLO helped provide reasonable suspicion?
I think, again, the court was looking at the totality of the circumstances, so that was a portion of it, yes.
But it was important to the court as part of its analysis?
On the merits of the case, yes, Your Honor. The court considered, in part, the BOLO, but it considered everything else as well. There was this BOLO where an individual called 911, reported a black Jeep at around midnight that was suspected of DUI. That Deputy Smith reported within less than 5 minutes, within 1 mile of the reported location, so a close geographic location, saw a black Jeep, and then when Deputy Smith began following it, he described the defendant as jerking within her lane, which he said is indicia of DUI. And so
was it a proper BOLO in your view? For example, let me rephrase. That was a terrible way to phrase the question, General. In your view, could the BOLO itself have given rise to reasonable suspicion?
I think that the BOLO by itself, at best, would have been a very close call and almost certainly would not rise to the level by itself of reasonable suspicion.
Is that because, in part, that the person calling in the original complaint was unidentified?
Based on the information we have at the suppression hearing, yes. The officers only testified that we got this BOLO. The state didn't really dive any deeper because we had the officers' observations as well. But yes, without this person's identifying information, without them, at least to our knowledge, specifying what the defendant was doing to specifically, right, that was indicia to them of DUI.
So typically in a BOLO situation, at the motion to suppress, the state will call, the state actually may be required to call as a witness the person who provided the initial facts in the BOLO to give rise to reasonable suspicion, whether it's another law enforcement agency, whether it's a complainant. Here, the citizen informant, if it is such, never testified at the suppression hearing. Is that correct?
Yes, Your Honor. They did not testify. Okay,
all right. But the larger point, I guess, from the state's perspective is this. But tell me if I'm in error. Irrespective of the merits of the BOLO giving rise to reasonable suspicion, the trial court relied upon the BOLO as part of its finding that reasonable suspicion existed, and the failure to incorporate that issue into the certified questions in any way is an issue when we're talking about compliance with Preston. Is that the state's position?
I think so, Your Honor. A sort of judicious or liberal reading of Rule 37 might not need to get into the trial court's, the bases that the trial court relied on. I think that the language in Preston is the trial court's findings, which might just be the overall, the officers had reasonable suspicion of X, Y, and Z. But certainly Rule 37 could be read to say that you also need to include what the trial court relied on, and that would fail under the defendant's issue statements. But again, I think also this goes to the dispositiveness of it. Again, all of these certified questions focus on this failure to maintain lane, and that was not the trial court's ruling. And it's on page 52 and 53 of the technical record. The trial court found, and I'll quote, "The officer was investigating whether or not the driver of the black Jeep was impaired." And again, it reiterated that the officer, quote, "had reasonable suspicion that the driver was driving while under the influence." The fact of the matter is, the trial court did not find that officers had reasonable suspicion to initiate a traffic stop based on this failure to maintain. And so all of these certified questions, whether this court determines that the defendant did or did not commit this traffic violation, would not be dispositive, because that doesn't change the trial court's ultimate ruling. So again, the defendant has failed to require it based on dispositiveness, based on the failure to include the trial court's reasons, and based on the failure to include their reasons in the certified questions for review. Should this court determine that the defendant has complied with Rule 37, in the alternative, it should affirm the judgments, because the trial court properly denied the motion to suppress. Again, here we have a trial court relying on the totality of the circumstances. So while the BOLO itself might not independently rise to the level of reasonable suspicion, it certainly adds to that. And when you have the BOLO, you have the defendant being in the same geographic location, driving the same black Jeep, or driving a similar black Jeep at midnight when there aren't many cars on the road. And then Deputy Smith sees the defendant jerking. And I want to note that the testimony was that the defendant jerked within her lane, which is a little bit distinct from Benet. I know Judge Greenholz mentioned Benet, and there the defendant was sort of casually weaving. And so it's a small distinction, but I think it's another little straw on top of the camel's back. And so when the trial court looks at the totality of the circumstances, it reasonably determined that officers had at a minimum reasonable suspicion of driving under the influence. And one other thing is, I noticed that the defendant today has mentioned that maybe her plea was not knowing and voluntary based on these understandings that they had come to. That's not an issue before this court, and so this court does not need to consider that when making its opinion. If this court doesn't have any further questions, again, we respectfully ask that this court either dismiss the appeal or affirm the judgments. Thank you.
To address the last argument first, so to speak, I was just merely making an observation. I mean, I wasn't trying to incorporate that in, albeit if the court was receptive, I certainly would take whatever I could get, as a blind squirrel finds a few nuts occasionally. But that being said, I don't need to read Rule 37 to you. I mean, when you read Rule 37 with regards to the sections, particularly with the requirement, the judgment of conviction or order reserving the certified questions that's filed before the notice of appeal is filed contains a statement of the certified question of law that the descendant reserved for appellate review. Question is stated, reserves the certified question identifies clearly the scope and limits of the legal issue reserved. And I guess we get to a hyper-technical reading with regards to that. But I think when we look at particularly the trial record, particularly in looking at it in light of Puckett and other decisions, particularly with regards to Officer Smith's observations, that he testified that outside of the BOLO, he never saw Ms. Cates actually violate any traffic laws. And that's Technical Record Volume 2, 21 and 24. So that being said, if you don't have any violation of the law, then if we're going to get down to the point that basically an officer can articulate anything that they could plausibly think, not that violates the law, but that triggers something. I mean, I don't know how far we go.
Is there a slight difference, though, between the officer saying I didn't identify any violation of traffic laws and driving, which might not itself violate traffic laws, but is indicative of impaired driving?
It may have been an inartful wording of the question, because I'm the one that posited it to the officer with regards to that, and because we were dealing particularly with roadways lined for traffic and, a two-lane roadway as far as that and in that context. But that being said, the Attorney General doesn't go back. There's no distinction drawn with regards to it later. I mean, effectively, I think both sides have conceded that there was no violation of the law, quote unquote, albeit the Attorney General may take issue with whether or not there is reasonable suspicion to stop somebody for impaired driving. But that being said, if we're going to stretch so far as to not have an officer make any independent observation, effectively we're going to be in a position where, as we've sort of seen the progeny from Benet forward, we just eliminate all reasonable suspicion that the officer can just stop somebody because they want to stop somebody. And I mean, that's where we're getting to if we don't have, at least some limits put upon it. And if an officer can't articulate some, if you will, violation of the law or reasonable suspicion of it, at least at that point in time, I think there's a real problem there. And I mean, to utilize, I guess, the well-used term that we all hear in these opinions, I mean, it becomes a slippery slope. I mean, and it becomes one that becomes insurmountable for a defendant to meet as far as constitutional seizure rights, in that effectively law enforcement can just effectuate a stop at any point in time. And so I think under the reading and under the reservation that we've done, I think we have satisfied at least the threshold of Rule 37, and Ms. Cates ought to at least be able to have this court consider her argument with regards to the same. Obviously, the argument that I was making was an aside because Ms. Cates' plea was based upon that. Not that it would be dispositive of anything today, but that's just simply it. And, you know, it creates that situation wherein a defendant ought to be able to reasonably rely upon not only the advice, because I would find fault with myself as well, because it would be disingenuous for me not to. I was defense counsel there, as well as, not to be hypercritical of the judge associated with it, the trial judge, but and the attorney general. I mean, obviously, it came and got presented to this court with the anticipation that the requirements of Rule 37 had been met. Otherwise, we'd seen the trial judge reject it associated with that, and we would have likewise seen no, if you will, consent by the attorney general. Otherwise, we'd just simply have a situation where attorney generals and trial judges, and by no means would I impute that they would conspire together to effectively create another pitfall for a defendant to fall in. But I think under this set of circumstances, I think at the base level, the requirements basically of 1 through 4 of subsection A of Rule 37 had been met to the extent that that was what the intent was to do, to confer jurisdiction. And then when we've got the set of circumstances associated with the basis for this stop on that October 6th, I mean, I think Officer Smith's got to have more than just, I saw someone jerk between the lines, because there's no video. So hence, it becomes impossible to refute what the officer says, at least under that circumstances. And with that, I think I'm out of time. Thank you.
Thank you.
Thank you, sir. Thank you all.